is aimed at the retail community to hopefully demystify the subject and provide some useful insights into the practical things that retailers need to consider when embarking on their plans for making sure that their organizations are compliant. For the purpose of making sure we can give you some really good information, we are joined on this webinar by Matt Johnston. Matt Johnston is a partner at White & Black, a law firm that specializes in the subject. Today, we are going to focus on the basic building blocks, the information that's necessary to understand before you start formulating your full plans for GDPR. So we're going to look at what personal data means in this modern age with the onset of so much technology that we take for granted, where is the boundary of personal data considered to be. So we'll look at what's changed in regard to the Data Protection Act. We'll also look at the important criteria for the reason the regulation exists, which is to ensure effectively that when businesses use personal data, they use it for lawful and fair processes, and that they show with transparency consumers how that data is going to be used for the purposes of conducting business with them. So we're going to take you through those building blocks. Matt's going to give you the detail in terms of how to interpret the core elements of GDPR in that regard. But I think it's probably worth us just stepping back a little bit just to look what is GDPR really all about. And there are two key principles that we need to think about. The first one is that this is to ensure that data that belongs to the identity of any individual living within the EU is protected, and that in GDPR, what we see is the advance of new benefits, new capabilities, new rights related to EU citizens, which we'll explore as we go through this seminar series. But first and foremost, it is about protecting the rights and protecting the data that belongs to an individual. But because we live and operate within the European Union, from a business point of view, it's also to ensure that where the Data Protection Act perhaps failed in the past is it was never able to achieve a unity of purpose across Europe. What this regulation is all about is trying to make it easier for businesses to operate in a consistent manner across the EU member states. But as I say, at the heart of it all, it is about ensuring the principles of lawfulness, fairness, and transparency. And I genuinely believe there's been a lot of fear, uncertainty, and doubt, FUD as we call it, peddled around GDPR because people are unclear of exactly what is required of them. So hopefully, after today's seminar, at least the basic building blocks will be understood. We will take you through some of the differences to the DPA, and I think the difference between the DPA, the Data Protection Act, and the General Data Protection regulations is really more about the likelihood of enforcement, the likelihood that the penalties now associated with non-compliance are more significant, and the regulator, the Information Commissioner's Office, has more powers to enforce. But the underlying principles of what we should be doing to operate in a fair and legal process arguably haven't changed that much, and hopefully we'll make that a lot clearer as we go through this process. However, caveat emptor up front, it's important to understand that as this is principles-based regulation, that this is not all 100% defined or prescriptive. In other words, it has to be interpreted, it has to be applicable, it has to be considered for each and every retailer to ensure that it's fit for purpose for them in regard to these principles of protecting the rights of citizens and operating in a consistent manner. So over the course of the next few weeks, we will be publishing other seminars on the subject. Today, we're dealing very much with the scope of personal data processing and consent. In our next seminar, we will look specifically in, okay, what do we now need to do with this information to ensure our internal operations as retailers are ready and fit for purpose to demonstrate compliance when GDPR becomes enforced? Because whilst it has been adopted by all EU member states as at today, it technically is enforced from the 25th of May 2018, and that's when the UK Information Commissioner Office will have the powers to effectively award fines if necessary to ensure that organisations pay appropriate care and attention. But as I say, let's not focus on the negatives and focus on the key issues of understanding what has changed from the Data Protection Act and what are the essential elements that we need to be able to be understanding in order to prepare our organisation. So with that in mind, what I'd like to do is now formally hand over to Matt, and Matt's going to take us through those basic building blocks. Matt.
Thank you, Andy. So the first thing that's worthwhile speaking about is how the Data Protection Act and the General Data Protection Regulation actually apply. And both these laws apply to personal data. And the definition of personal data between the DPA and the GDPR is largely the same. So personal data is data about an identified or identifiable natural person, an identifiable person being a person that can be identified directly or indirectly by a particular identifier, such as a name, an ID number, etc. However, there are certain differences and enhancements that GDPR is making to the DPA. It's important that the GDPR specifically now includes online identifiers such as IP addresses, mobile device IDs within the concept of personal data. Also includes location data, so where a potential customer might be ordering products from. So the definition, albeit similar to DPA, is clearly aimed at future-proofing and technology advancements. A couple of very important points to note in relation to personal data is two concepts, one of pseudonymized data and one of anonymized data. If we take pseudonymized data first, what that actually means is pseudonymization is a process that replaces or removes the information within the data that identifies the data subject. So pseudonymized data is still captured by the GDPR, but it's the process of actually removing that identifiable information. And then that identifiable information is stored by the data controller separately from the other data, and it's effectively a security measure that the data controller can then reverse. So removing the identifiable data, and then you can reverse it to re-identify. So that pseudonymized data is still captured by the General Data Protection Regulation, but it is a very good security measure to take. Anonymized data, however, is a bit like a bit of a retailer data protection silver bullet, as properly anonymized data immediately takes personal data outside the scope of the GDPR because it is no longer personal information. The process of anonymization, however, is slightly easier said than done. It's the process of irreversibly destroying the way of identifying the data subject. So effectively, it will only be used by a retailer when you no longer need to know the identity of the data subject. So for example, if you were using it for certain website analysis or market analysis processes. So that's the definition of personal data and how GDPR applies generally. One thing to quickly be aware of is that at EU level, there is currently a new e-privacy regulation which is in draft. And this e-privacy regulation deals with matters such as direct marketing, cookies, and tracking technologies. And what this e-privacy regulation is attempting to do is make it easier for customers to accept or reject cookies via browser settings. So moving away perhaps from the model at the moment with various cookie pop-up consent options, and also making it clear that retailers will not always have to obtain consent for cookies. For example, if it was just a non-intrusive functional cookie required for the delivery of a service, such as a cookie that recalls shopping cart history or maintains login information for future shopping sessions. So that's a piece of regulation to be aware of in the future. Moving on from the definition of personal data, it's worth speaking about the basic principles of the General Data Protection Regulation. And as Andy said, it's a principle-based piece of legislation, which means that a lot of the aspects are very general and are supported by codes or guidance, etc. As with the DPA, there are a number of key principles in the GDPR, which we'll run through now. The first is that a data controller / retailer should not use personal data for an incompatible purpose. So for example, if the data is collected for fulfilling an order, reselling the personal data to a third party is arguably such an incompatible purpose. However, there may be certain compatible purposes as well that would be relevant to retailers, such as providing the data to a postal service for delivery and also for direct marketing. So not necessarily for the actual act of direct marketing, but for the process of perhaps moving the data from database A over to the direct marketing database. The next relevant principle is around data minimization. What this effectively means is that a retailer should not be collecting more personal data than what it needs for the purpose for which it is processing it. So that is around the actual, for example, the fields that a data subject may be required to fill in. There needs to be a process gone through by retailers to understand exactly why they're collecting that data and make sure they're not collecting more than is necessary. Accuracy of the personal data is also a principle under the GDPR. Unlikely to be a massive issue for online retailers, as a lot of the data that is actually being collected by retailers will rely on consumer data entry, so registration processes, ordering online. However, the processes that a retailer must have in place would need to clearly deal with how to correct or change that data as and when a data subject updates it. Next principle is around storage limitation. Effectively, how long does the retailer need the personal data for? There's no actual dates that we can apply here. Effectively, the process just needs to be gone through where the retailer understands that they collect the data for a particular purpose. How long do they actually need to hold on to that data to continue to process it for that purpose? And the key here is going to be evidencing what the thought processes are that the retailer has actually gone through. And a good example is thinking about guest information versus a registered user. Guest information, the retailer may only need to actually retain for the purpose of fulfilling the order, or perhaps some other analytical purposes, as opposed to a registered user where that data obviously might be kept for much longer. The next principle is known as integrity and confidentiality. Effectively, in Data Protection Act land, this is around the security obligations that a data controller online retailer must take. And then accountability and record keeping, effectively demonstrating compliance. And this is where, as Andy mentioned, a lot of the changes in GDPR are going to come into play around demonstrating the awareness, the training, the thought processes that the data controller / online retailer have been through, and actually demonstrating compliance with those principles. So now we move on to the concept of lawful processing. Just a quick note that the General Data Protection Regulation and the Data Protection Act differentiate between two things. Processing must be lawful and fair. They are two slightly different issues, so we'll deal with them separately here. For lawful processing, there will need to be a condition for processing satisfied which are contained within the GDPR. So for any personal data that an online retailer is processing, one particular condition in the GDPR needs to be satisfied. If an online retailer is actually processing what's called special categories of personal data, so health information, racial or ethnic origin, biometric data, then there'll be a supplementary or second category of condition for processing that would need to be satisfied. However, it may be unlikely in the online retail context that very much special or sensitive personal data will be processed. Regardless, it is important to identify what condition for processing the online retailer is relying upon, and then keeping a record of that, and again, that thought process. There are a number of conditions for processing what we've called normal personal data, so non-sensitive, a lot of which won't be relevant for online retailers. The three that are likely to be relevant are consent, which we'll touch upon later in the session, performance of a contract, so completing the actual online order, or legitimate business interests, so business improvement, perhaps direct marketing. So those are the three that we're going to have a bit more of a think about. We take the first one, performance of a contract. Effectively what this says is that if the processing is necessary to perform the contract, then you have a condition for processing under the GDPR. There is no difference between the Data Protection Act and the GDPR in relation to how that condition for processing actually operates. However, it is likely to become a lot more important because of the changes that have been made to how consent can or cannot be obtained under GDPR. So because the consent option is going to become more difficult, it is very likely that performance of a contract is going to become a lot more relevant and a lot more relied upon by online retailers. The next condition for processing, legitimate interests. So this is where the data controller online retailer considers that the processing is necessary for its legitimate business interests. However, you have to balance up the business interests of yourself with the data subject's privacy rights. So it is not simply a matter of saying, yes, we have a business interest for this, therefore we can process it in this way. It needs to be looked at as a balancing act. In an online retail context, this is likely to be used to allow those other kind of business processings that you would expect. So service and product improvement of a website, etc. And always consider what would an individual think is unusual or slightly creepy in the processing. As it gets more towards the unusual types of processing, there could be an argument that actually it's less likely that you're going to be able to use legitimate interest to justify that, because it's a bit more unexpected for the data subject. And then below, legitimate interest could be used for direct marketing, as we spoke about, so moving data from system A to direct marketing system, but not around the actual consent mechanism itself, which is slightly different. Or intragroup transmissions if you're part of a group of companies. The next thing we're going to look at is around what are commonly called privacy notices or fair processing notices. And what these fair processing notices do is they deal with the fairness element. So we've spoken about the lawful element of processing. This is around the fairness element of the processing. So it's not consent. Consent is different and it's commonly confused. Consent deals with lawful processing. Fair processing deals with the fairness. Processing must both be clear, fair, and lawful, i.e. transparency and awareness. Fair processing notices are clearly used under the Data Protection Act. However, there are different rules under GDPR for the content of fair processing notices, plus how you actually introduce those. So, for example, when an online retailer is collecting personal data directly from a data subject, so when the customer completes an order, there are certain rules and processes around how that fair processing notice is introduced and what the content of that fair processing notice should be. The content being enhanced from what is currently under Data Protection Act. There's also a separate section in GDPR that deals with what happens when a retailer is collecting personal data about a data subject from a third party. So where, for example, you would buy in a third-party database. In that situation, the content of the fair processing notice is very similar to what you would have to introduce if you were collecting directly from a data subject, but there are some additional things you must do. So you would need to set out what the source of the personal data was, so who the third party was, and also what exact personal data you are processing, because the rationale being that the data subject doesn't know that. They are not contributing that data to you directly, so they are not sure what you're actually processing from the third party. However, that does not mean you need to have two separate privacy notices. They can be combined. So it would not be a matter of overcomplicating the situation here. It would be effectively future-proofing your notice from the outset to make sure you're reducing your admin burden later on. The next important thing to note is how to actually provide the fair processing notice. So there are a number of ways. Clearly, you could do it orally. If there was an order made over a phone, you could do it in writing, or most relevant, you could do it electronically as part of the customer's journey through the process. One quick note is that it's not always required to introduce a fair processing notice, but these exceptions, as and when you don't have to, are very limited, and it kind of assumes a certain level of basic processing, which most online retailers would go beyond. So the example that the ICO uses is when a person orders a book from an online store. If that personal information was only used to effectively collect the book out of storage, send it and take payment, then arguably you wouldn't need to provide a fair processing notice. However, most online retailers would do more with the data than just that. So a fair processing notice is likely always going to be required. Fair processing notices have a number of practical results. The main thing is that a fair processing notice is there to keep a data subject informed. It's about them understanding what is happening with their data. So on the flip side of that, it can be used by online retailers to actually enable a number of things. So for example, it could enable data sharing. If you are using an online app for the purchase of goods, that personal data which the data subject is contributing may need to be shared with a number of third parties. So obviously the retailer would need it, but also the app developer might need it, perhaps the provider of the payment gateway might need it, and perhaps others involved in the order fulfillment might need it. So the fair processing notice is a tool to enable you to satisfy the fairness element of the data sharing. And it also, where it becomes most important for online retailers, is around those supplementary uses of personal data that it wishes to make. So if there is a certain processing that might not be contemplated by the data subject, so for example, analysing how that particular customer behaves with their online orders and what they order, then the fair processing notice can set out those processings that are being done by the online retailer, and it does help with the fairness side of it. The format for fair processing notices is also relevant. So traditionally, you'll probably be used to seeing the classic click on the fair processing notice privacy policy, you get taken off to a number of pages of fair processing information. However, there are a number of other options that are available and that the ICO mentions in their code of practice, which has been updated for GDPR. The first are layered fair processing notices. What these are is they offer various bits of information the further down the layer the actual data subject goes. So the first might just say, we process your personal information for fulfilling your order and for certain other business purposes. To find out more, click here. That then takes you to a slightly more detailed one. And if the data subject was really, really interested, they could go to the most detailed fair processing notice. So it helps enhance customer experience, and it also enables the customer to actually see the bits that are relevant to them. The use of icons is also recommended in the sense of, especially on an app, where you can actually have an icon for, you might have an icon for transfers that someone can click on to see where the data's been transferred to. You might have an icon for retention periods where the individual can click on and see how long you keep the data for. So in terms of a website experience, it may not be necessarily relevant, but in terms of a smartphone or an app, it's going to be definitely an option. The third thing that the ICO speaks about in its code of practice is what are known as just-in-time notices. These are kind of like the layered notices we spoke about earlier, but effectively they pop up and provide brief information to the customer at each point of their journey. So one thing to keep in mind there for online retailers is, although that can be quite a privacy-friendly approach because the individual knows exactly what might be happening with their data just before it happens, it can perhaps impact the customer experience quite a bit. The next thing to be aware of is how and when to introduce fair processing notices. So the first thing we would recommend is analyse your existing fair processing notice. It will, in all likelihood, deal with a number of things that you will have to deal with under GDPR anyway. So we would not recommend, unless you have a number of additional processings that have been happening, justifying a completely new notice, or if you don't have a notice at all, we wouldn't normally recommend drafting a whole new one. We would normally recommend amending the old notice to comply with the additional requirements of the GDPR. And those additional requirements are very well set out on page 34 of the ICO Code of Practice on Privacy Notices. The next thing to speak about today is consent, which is one of the conditions for processing. So this flicks back into the lawfulness argument we spoke about earlier, which we spoke about performance of the contract, legitimate interests. Consent is one of those, and it has been traditionally used quite often. So there's a concept of normal consent, which is defined in the GDPR, and then there's a concept of explicit consent. So if there's any processing of sensitive personal data going on. The issue with consent under GDPR is that it's going to be much harder for retailers to obtain it than currently under the DPA. So there is some draft guidance that the ICO has put out, and the final version is due this summer. But the thrust of that guidance is that because of the way GDPR has taken consent into a slightly more detailed realm, it will become much harder to actually obtain. So what is valid consent under GDPR? So it must be unbundled, which means that it's not hidden anywhere. For example, within the actual fair processing notice, that's definitely not appropriate anymore. It needs to be granular. So if you're doing separate processings for which you're relying on consent as the condition for processing, you need to have separate consents. You would need to name any entities that are relying on the consent, so third parties, for example. The consent must be documented, and it must be easy to withdraw. Effectively, if a data subject cannot withdraw their consent after giving it, so they can't ask you to stop processing their personal data based on that consent, then it's not going to be consent. So as you can see from that, it's going to be relatively difficult in your business as usual processes to rely on consent. If you did want to rely on it, however, the analysis you'd have to go through would be review your existing consents. And if they do not comply with the new GDPR requirements, then you must obtain new consents that do comply. One quick note on the employee consent issue. So this is a common one under Data Protection Act already, but it just reiterates itself under GDPR in the sense that a consent, there cannot be any relationship imbalance. So for example, in an employee-employer situation, it's going to be very unlikely that the employer could obtain the employee's consent to the processing. Some other things to be aware of for consent are that they must be refreshed. So just because you obtain, let's call it a new GDPR consent now, that doesn't mean that that is fine for as long as you want to rely upon it. You must assess and make a decision in terms of how long that consent would remain valid for. And again, because of the principles-based aspect of the legislation and because of the guidance, we're never going to be able to give a very clear date on when that consent must be refreshed. It will really depend on what the processing is. So if you are using consent to allow your processing for quite business as usual, everyday product sales, it might be that that consent could be refreshed perhaps every 6 to 12 months. Arguably, if you're in luxury and people would normally only order from you, say once every couple of years, then it may be that the consent is valid for longer because it's an occasional purpose. But the key with all this, again, is about documenting the thought process and at least demonstrating that you've gone through the process of considering these issues. The ICO has given quite a clear steer in their draft guidance that consent is going to be quite hard to obtain. And effectively, in an online retail context, if you think that it's too hard, then you're probably using the wrong condition for processing. You're probably more likely to be looking at performance of a contract or business purposes. But a word of warning, we don't have guidance on those other conditions for processing yet, so we're not entirely sure how they're going to be interpreted, but that is the clear steer from the ICO. If anyone still wants to use consent, then there are a number of practical implications. And consent is likely to only be used in an online retail context if you are looking to do something unusual with the personal data above and beyond fulfillment of the order and your normal business processes. So if you get to the route where you think, actually, we do need to rely on consent to enable this slightly unusual processing, whether it's selling the data to a third party or something else, there's a few practical things you need to do. You need to make sure that it's prominent, concise, easy to understand in plain English, and separate from things like online terms and conditions and privacy policies. You need to make sure that you include in the consent who the parties are that are relying on consent as mentioned earlier, why you would want the personal data, what you will do with it, and that the consent can be withdrawn. So consents can be very clearly drafted and effectively express for the data subject to agree to them. There are a number of methods for obtaining the consent So these are probably relatively straightforward for a number of online retailers. Ticking in the electronic opt-in box, clicking an opt-in button or link online, selecting from equally prominent yes/no options, choosing settings, responding to an email, or answering yes/no in a clear oral consent request. But effectively, what always has to happen is that consent has to be recorded. It's not simply a matter of obtaining the consent, for example, via a clear oral confirmation and then forgetting about it. That would need to be recorded. So there need to be hard copies, or online you might be able to use a cryptographic hash to record that. So what needs to be within that record of consent would be who, when, and how the individual consented, the content of the consent, and then clearly whether the consent was withdrawn. So with that, I will hand back over to Andy to finish up.
Thanks ever so much, Matt, and I appreciate the insight you've given us into those sort of 4 building blocks. As I say, the first element really on the journey to being ready for GDPR is really understanding what are the areas that we need to focus on. So hopefully today is giving you a little bit of an insight into those key areas. As a quick recap, I think the points we'd want you to take away with you are the fact that GDPR is already adopted. It just will become formally enforced as of the 25th of May, so we cannot ignore it. It is something that is happening regardless of Brexit. So we do need to make sure we pay attention, and we have this window between now and the 25th of May 2018 to make sure that we're ready. We're obviously making clear the scope of personal data has changed, so things now such as a mobile phone itself, the identification of it, IP addresses that are used, etc., now get covered under the description of what personal data is. But I think the overriding thing we would want retailers to take away from this first seminar is that whilst GDPR has more teeth, it is largely building on the practices that were brought about by the onset of the Data Protection Act, and therefore in terms of a step change it's not that material, although it would be fair to accept that maybe not everyone has fully adopted the Data Protection Act quite to the extent that it was ever intended. But we would say that we think the biggest impact is on internal operations of retailers. Do we understand what personal data we capture? Do we only capture data that we need for legitimate purpose? Do we have appropriate notices up for our consumers? Do we have clarity on the basis of fair processing and legal processing? And certainly the steer I'm taking from the advice so far is that, with the exception of a marketing activity, which will be covered under the e-privacy regulation that Matt talked to earlier, and with the exception of if any retailer deals with special data, which is less likely, then really we're encouraging retailers to focus on ensuring that their legal processing methods are based upon performance of a contract, legitimate interest, and not to rely on consent. That said, you do still need to rely on consent around marketing activity for the foreseeable future, and we will keep you updated with that over time. So there are a bunch of actions we would ask you to think about. We do think every retailer, regardless of size, should have someone within that organization who's the go-to person, the owner of a program of activity around awareness in their business for GDPR, so that the management and staff all know what's expected. We do think if you haven't, and most organizations won't have, you should conduct a review of what personal data is held and which third parties you use that may have that personal data, because as we move forward in this series, we need to look at how you have back-to-back contractual and operational relationships with people that access that data. Make sure that you review your privacy policies, and we have to think about how, by the time we get to May next year, those privacy policies move away from the footer of your website to becoming more informative within the flow of a customer journey without interrupting and without adding more clicks. So it's very much around design and presentation as opposed to additional process, but we do need to bring it out from the footers of websites into more mainstream journeys now. And we need to obviously ensure that if consent is required, the strong advice would be, because you actually have to evidence how consent was achieved, that most people would have to probably go and regain that consent beforehand in the event that consent is actually required. All of that said, The reality of how we need to prepare our operations is the focus of our next seminar. So if this seminar has been useful, we hope you will come and watch or participate in the next seminar. Our contact details are up on screen now, and Matt and myself will be more than happy to hear from you if you have any specific questions on the content we've raised today. So Matt, thank you very much, and everyone, thank you for listening.